What does that have to do with him punching her, throwing a vase at her, kicking her? What's love got to do with that? Good question, Judge. He was an actual altar boy growing up. He's a very religious man. Growing up, he was religious. You got to let him out. Yes, he's on video beating the shit out of that girl, but he's religious. Attorneys for Sean Diddy Combs have filed an appeal of the judge's ruling denying him bail. The new filings also include the full transcript from Judge Andrew Carter's bail hearing on September 18th. This transcript is basically the defense and the state arguing on whether or not they think Diddy should get out of jail on bail. His defense lawyers bring up that he's a religious man, which is obviously very ironic. I'm going to read the whole thing. Hit subscribe. Here we go, boys. So here we go. Here's the notice of appeal. Order denying release on conditions. For the state is Emily Johnson. All these names right here, you'll see. They're kind of hard to pronounce, some of them, but these names right here. And then Mr. Agnifilo and Miss Teeny Garajos. Judge says, I've seen the submissions. I reviewed the previous submissions that the parties made to Magistrate Judge Tarnofsky. I've looked at the transcript from the bail hearing yesterday. Let me just share with you my initial thoughts. The government primarily seeks detention based on a risk of flight and the danger of obstruction of justice or witness tampering. Regarding those two bases, first, my lesser concern here is risk of flight, although that is a concern. Certainly, Ms. Combs is a risk of flight. Defense counsel has submitted evidence regarding the efforts that he and his client made to try to show the court and the government that he is not a risk of flight, like giving up his passport like 6 months ago or whatever. The government has again attempted to prove that he is a risk of flight, and the government has to do more than just simply prove he's a risk of flight. They must prove that he's a risk of flight such that no condition or combination of conditions will reasonably assure his return to court. The package that's been submitted by Mr. Combs, I think, does not give the court a reasonable assurance that he would return to court regarding the issue of whether or not the government has proven risks that such no condition or combination of conditions would reasonably assure his return to court. Remains a bit of an open question in my mind, but certainly the package has been submitted as not sufficient to reasonably assure his return to court given his wealth. My bigger concern deals with the danger of obstruction of justice and the danger of witness tampering. That is a real concern that I have here, but I just want to give counsel my thoughts as to what I primarily concerned about. So now the state, Ms. Johnson, says this case is about Sean Combs' physical and sexual violence against women and others. This physical and sexual violence has gone on for decades. It's also about the vast efforts he undertook using his extensive resources to cover up his crime. In other words, the very conduct he's charged with shows his dangerousness, his resources, and his willingness to lie and obstruct. Yesterday, Judge Tarnofsky recognized this when she found that there was no conditions or combination of conditions that could assure the safety of the community or the defendant's appearance in court, and she detained the defendant. Defendant used force, threats of force, coercion to cause female victims to engage in sexual activity with male commercial sex workers that he referred to as freak-offs. These were elaborate sexual performances that he arranged, directed, masturbated during, and often electronically recorded. Sorry, I know it's not funny, but this guy's just such a fucking weirdo. These began in and around 2009 and lasted until at least this year and often took place over multiple days and frequently with more than one escort. These freak-offs were arranged with the assistance of members of his enterprise who set up rooms, stocked the rooms with supplies, so we know all this. Arranged the travel, delivered cash to escorts. Defendants used narcotics so that female victims could continue to participate in the freak-offs despite exhaustion and fatigue. Absolutely insane. Ketamine, ecstasy, GHB, and others. And victims themselves and communications that the government has seized describe themselves as being drugged during these freak-offs. So they've obviously seized a lot of shit now. Dude, the amount of evidence against this guy is probably overwhelming. He recorded the freak-offs and did that, at least in the part, so he could keep the recordings and use them as blackmail. It's also in black and white and communications that the government has seized. For example, in December of 2015, a victim texted a defendant and makes explicit reference to this type of extortion. This is the quote: "You know what sick and disgusting shit I was reminded of the other day? You forcing me to do something else, which I'm not going to mention on the public record. Or you were going to leak some FO shit." FO standing for freak off. I mean, black and white right there. You forcing me or else he's going to fucking release this shit. What an absolute sicko. Defendant recorded these women engaged in freak offs. He threatened them with those very videos to get them to engage in even more. And the defendant makes a lot of claims yesterday in his papers about the victim's motives and speaking up now, but the message is from 9 years ago. And I suspect that we'll hear that we should ignore these types of things because they're old, but this isn't the only time there's communications that explicitly reference this kind of blackmail. In fact, the same thing happened much more recently, several years later. After 2015, when a different victim said, here's a quote: "He just threatened me about my sex tapes that he has of me on 2 phones. He said he would expose me. Mind you, these sex tapes where I'm heavily drugged and doing the things he asked me for the past 3 years." That's just 2 examples of defendant's egregious conduct in extorting and blackmailing victims that have happened years apart, and so it's rich when the defense submission filed today accuses the victim of extorting the defendant. Not looking good. Let me be clear, the only person who was engaged in extortion in this case repeatedly is the defendant. At least a dozen witnesses will confirm that they personally observed the defendant's violence towards women or the injuries that were sustained as a result. In addition to the physical violence towards women, there's also evidence of the other violent acts, including physical assault on individuals, including employees, witnesses to violence, kidnapping, and arson. The defendant surrounded themselves with used firearms, so let's talk about all the ammunition he had and his residences. They were licensed guns to the security team. They were stored in defense homes and we had access to them. We're much more concerned about the defaced firearms hidden in his personal closet, and that was our focus. but it's worth noting that defaced guns have nothing to do with our security and everything to do with dangerousness. And even beyond that, we consider the additional guns the security team has as even greater access to firearms. Yeah, defaced firearms are obviously very serious. His head of security was served yesterday with a search warrant for his devices because of what our investigations revealed about his own personal involvement in the offense conduct. And his offense is under investigation by the government. I said that in my last video. I was like, bro, they're definitely gonna charge more than just him, right? Like, they're gonna start arresting people that are around him. Talked about the March 2016 incident on camera of him running on in the hallway on the robe. Contrary to defense counsel's argument yesterday, which attempted to inaccurately recast this incident as just a fight in a relationship. Yeah, fucking beating the shit out of your girlfriend is just a fight. What a terrible defense. Our powerful evidence of trafficking, a recorded example of defense use of force in connection with the freak off. So they had an escort with them in the hotel room when that happened, apparently. Contends that this incident only involves the defendant and the victim, but this is wrong. We have multiple sources of evidence to demonstrate there was at least one commercial sex worker who was with the defendant and the victim in the hotel room prior to the assault. Violently assaulted the victim who was sneaking out of the room to leave. You can see in the hallway surveillance video, she isn't even wearing shoes as she is leaving. She's leaving as fast as she can because she's trying to get out of there. She's in danger. In the video, the defendant storms out room with nothing but a towel, punches her, throws her to the ground, kicks her, attempts to drag her back to the hotel room, throws a vase at her. This guy's just such a little piece of shit, dude. Text messages in the days following confirm injuries. I have a black eye and fat lip. You are sick for thinking it's okay to do what you've done. I still have crazy bruising. This guy's so cooked. There's text messages and everything. Footage of him beating the shit out of, like, he's so cooked with that incident. Dangerousness of the defendant. It's evidence that he is to try to minimize it. He casts it as a misdemeanor assault arising out of a lover's quarrel based on the fact that he wanted to get his clothes back, but that's not what happened here. Defendant tried to bribe a hotel security officer. We know about all this. Security guard refused to be bought. Then defendant's staff got involved contacting hotel security to get the footage of the incident and keep it from being seen by anyone. Well, yeah, it took fucking 7 years for it to get out. Defendant argued there was no criminal investigation, so there couldn't have possibly been obstruction. Defendant was just trying to prevent something embarrassing from becoming public. What absolute delusion. Yeah, you beating the living shit out of your girlfriend, piece of shit. So here's text Diddy sent. Call me. The cops are here. I got 6 kids. Yo, please call. I'm surrounded. You gonna abandon me all alone? Well, we don't have evidence that the police were actually there. The point is that the defendant knew he had done something that could elicit a law enforcement response, and he had to cover it up. His staff knew that the police responded to the victim's apartment. They have photographs of the responding officers' Los Angeles Police Department business card in their text messages, and their staff members remained in contact with the victim to ensure that she would not talk to the police. The defendant's employees trying to cover up his crimes, all at his direction, and the cover-up continued until last year after the civil suit was filed in November. The defendant ultimately admitted that he was actually the person in the video, but only after it was leaked to the media and only after there was indisputable proof of his identity on the tape. Yesterday we got more to the story that apparently his assault was precipitated by the defendant being hit in the head while he was sleeping, by his cell phone and his clothes being taken in a small overnight bag that you can see the victim walking down the hall with, in addition to her purse. This is apparently why he runs out of the hotel and nothing but a towel, but other evidence will show that's not what happened. But assuming that, punching, kicking, and dragging someone in and of itself is a crime, and covering that up is an act of obstruction. Yesterday the defense said they interviewed about half a dozen escorts who would dispute the government's account of what happened during the freak-offs. So defense is already going after escorts. Probably be like, hey, well, you want $20,000 cash? Come in this trial and testify. We give you 20 bands. You want 50? We can give you 50 bands. You just got to come in the trial, testify. Nothing happened at these freak-offs, all right? Ongoing, so I can't talk too much about this, but I will note that half a dozen escorts is just the tip of the iceberg of the number of escorts who have participated. Probably hundreds of escorts over the years, if I were to guess. Defense also spent a lot of time talking about how these freak-offs were between consenting adults and how the government was not claiming sex without consent. Abuse occurred in the content of at least one long-term relationship, which we acknowledge, but the government's theory does involve a lack of consent. When a woman is being beaten and coerced in order to get her to engage in commercial sex activity, those sex acts are not consensual. Focus of today's proceeding, however, is not and should not be on the dynamics of abusive relationships. Today's proceeding is squarely focused on the defendant alone and whether the defendant presents a danger to the community, and whether the defendant threatens the integrity of these proceedings, and whether the defendant presents a risk of flight, all of which he does. Defense counsel has made much yesterday and today in his letter about his misinformed view that there was not a sex crime here, and therefore the nature of his offense doesn't weigh in favor of detention. He's argued in essence that anyone who is participating in a freak-off wanted to be there. That flies in the face of the evidence in this case, much of which we've laid out to the court, but it also shows a misunderstanding of the law. When participants in commercial sex activity are threatened with the release of collateral videos, like those text messages I read, when they are threatened with the loss of their livelihood and housing, and when they're beaten both during and outside freak-offs, you saw a video of that, they cannot consent. That is trafficking. This view is especially evident when counsel spent time minimizing and horrifically understating the defendant's violence. The investigation has revealed evidence of numerous assaults against female victims and other individuals, choking, hitting, kicking, dragging victims by their hair, and they sometimes occurred in cars where victims' heads were slammed against the car window or in the floor of a car. And again, independent evidence like text messages confirms this types of violence. Without attributing any of these messages, I'm going to read 4 that make my point. I turn my head for a second and you get fucked up and you drag me down the hall by my hair. I have bleeding cuts. You hit my head 2 good times. When you get fucked up the wrong way, you always want to show me that you have the power and you knock me around. I'm not a ragdoll, I'm someone's child. And we don't just have texts, we also have witnesses who can confirm because they witnessed this violence and they witnessed the injuries. And this conduct took place behind closed doors, in houses, and hotel rooms, and cars, in settings that are not easily monitored by even the most stringent conditions of release. The defense violence was premeditated and spontaneous, and I think the text messages I just read highlight that. Exacerbate the difficulty of crafting conditions of release to ensure the safety of any person. How do you craft bail conditions that can address the defense's tendency to become violent at the slightest provocation, become violent, as the text messages say, when he gets fucked up to the wrong way? In fact, Judge Tarnofsky found the defense did not have the ability to control the defendant given his substance abuse and anger issues. Ooh, that's actually a good point. He's so all over the place. How does the defense really control him? Citing a case about the dangers of releasing defendants with a history of domestic violence. We've all heard stories of people that get out from domestic violence and then end up killing someone. There need not be an existing investigation or official proceeding. The defendant need not know about it. But we also show the defendant knew about this investigation at least as of January 2024, and he certainly suspected the possibility of an investigation after November of 23 when civil lawsuits were filed. He and his co-conspirators continued their efforts to reach out to potential victims of witnesses. So this is basically putting the nail in the coffin that he can never get out on bail because they've already been witness tampering. This outreach has included directly contacting at least one victim in November, constant contact with witnesses to the charged conduct, and with contacting of witnesses, including those who received grand jury subpoenas. As recent as July, 2 examples, communications between the defendant and a witness who received a grand jury subpoena. These communications are both prior to and following the witness meeting with the government, and the government has evidence that the defendant knew that this witness had received a grand jury subpoena, and both before the meeting with the government and after the meeting with the government, there were 14 total contacts between the 2 people. So he contacted one witness 14 fucking times, and he somehow knew about the grand jury subpoena. Another example, a witness with a grand jury subpoena in June was contacted multiple times by the defendant by phone, text in June and July, despite the fact that the 2 had not spoken in years. These efforts were also crafted to avoid detection. He used intermediaries to reach out to people, and in an instance I'll describe in detail, he recorded conversations with the victim on the device of a co-conspirator. These kind of efforts, these kinds of means, make obstruction even more difficult to detect when it's being done through other people and on other devices. The instance where I mentioned where the defendant directly contacted the victim in November 23, he placed 2 calls to the victim, both of which are recorded on the co-conspirator's phone. As a background that will help explain some of the things that were discussed, the defendant provides financial support to this person, so early on November 19th, which is 3 days after the filing of the civil lawsuit, the defendant received a text from his other person in response. It reads, "I feel like I'm reading my own sexual trauma. It makes me sick how 3 solid pages word for word exactly my experience and my anguish." Someone texted Diddy that. He is so cooked. There's multiple people that have all experienced this with him. In those recordings, he gaslit her and he attempted to convince her that she willingly engaged. But she pushed back. She told him she felt manipulated and clarified with his description of events and was not how she saw things. He repeatedly talks how he was not supposed to be speaking on the phone and not supposed to be using the phone, and he clearly instructs the victim not to text him. These statements clearly shows his state of mind. They show that he was on notice that there could be an investigation. Well, clearly, yeah, after lawsuits and everything, his lawyers were probably like, no more communicating with anyone. Defendant assured the victim that if she continued to support him, she ain't going to worry about it. Thinly veiled reference to his continuing financial support. And subsequent text messages explicitly clear that that's what he was talking about, because 2 days later he texts the co-conspirator in reference to the financial support. Make sure that blank, the name of the individual, is not doing anything dumb, like not having that rent paid on time. The defendant made sure that the financial coercion continued, clearly to keep the victim close. We do not think that the bail packages have enough conditions that focus on obstruction. We don't think there are conditions that can really keep the defendant from doing the types of things he's been doing, particularly because he's been involving other people in them. There's a massive amount of evidence. There's a massive amount of witnesses, a massive amount of electronic evidence. There's a massive amount of physical evidence that we seize. We have witnesses saying things powerfully corroborated by communications, by photographs, by videos, by documentary records, and text messages. And this is the evidence that we will use to prove the charge in the indictment. This guy's so cooked. All right, here comes the defense. So this is where it's going to get kind of funny, honestly, but defense is responding now why they think that he should be let out. I brought to court today in the 4th Afro, the handsome man who lost his hair at some point, is there. Okay, he's bald. Owns Sage Intelligence. He's a former New York Police Department detective. He worked in the DA squad, and he's had Sage Intelligence for, I think, about 15 years. And here's what we're proposing in addition to all of the other conditions. Personnel from Sage Intelligence, all of whom will be former law enforcement officials, will be monitoring the residents of Mr. Combs 24 hours a day, 7 days a week. 2 Sage employees there at all times. They will basically have full control of who enters and who doesn't. There will be a visitor's log that's kept, and we could have it shared with pretrial services every week or every day. He will not have access to a cell phone since there will be Sage personnel on site. If we want to reach him, we can reach him that way. He won't have access to the internet, so what I'm trying to fashion is a situation where any witness intimidation, if that is the court's concern, and I see that it is, will be completely nullified. It would be virtually impossible, and Sage would monitor these things. Make sure he doesn't have a cell phone. Make sure that anybody comes to the house is on pre-approved lists of visitors, and keep track of all the visitors. And we can make the list of visitors and provide to the government, to pre-trial, and the court. In light of the government's proffer today, I'm not going to go through all the things that I said yesterday. Your Honor read the transcript. We believe we have very significant defenses to everything that the government has said, and we have been conducting on the defense side a very significant investigation for 6 months. And I anticipate this is going to increase as we get closer to trial. So they've already done 6 months of defense work trying to build up a defense for this. Mr. Combs would be in the special housing unit if he was incarcerated in the MDC. That presents tremendous challenges to us given the amount of electronic evidence. It's a very difficult place to be as an inmate, and it's a very difficult place to get ready for any trial, much less a trial with tremendous amounts of discovery, as his case has. That is, he is deeply respectful of the court's authority. He is willing to show that he is responsible, that he can follow these directions, and he is mindful and has been mindful. We were giving the government assurance, giving up his passport. Miss Garagos and I flew to Florida. We sat with Mr. Combs in his house in Florida, and we said, "You're being investigated by the Southern District of New York for a number of serious charges. It's racketeering, conspiracy, it's sex trafficking, it's obstruction of justice, it's prostitution." We were right because we knew what they were looking into. We also knew it because there's a search warrant, and the search warrant had crimes in it. So he knew. He knew on April 1st. So the state is right, predicting that he knew he was being investigated, and it wasn't just the lawsuits back in November or whatever. Members of his family and friends are here today. They love him, they support him, and many of them gave up their passports over the last several months. We also made efforts to sell his airplane, which is in the process. We have a letter of intent to sell the airplane because I was concerned that if he had access to an airplane, that would give Your Honor a concern. I credit the government for not raising it as a concern, as I think it's not a concern because we're selling it, but significant thing is we had the foresight to try to sell it. Desperate, bro. We're on the 4th buyer. Yeah, whoever is rich and buys that, their name is going to be like connected to Diddy. The judge is getting annoyed right here. Can you just get to the point where you said that this doesn't relate simply to the risk of flight? It shows respect for the court. It shows that he's trustworthy. This is a serious process to him. Your Honor must have seen defense thumb their nose at the court and say, "Come find me." I'm going to show the court that the due respect it deserves. Wait, just because he turned himself in? Some defendants flee outright. If he's aware of this April 1st, 2024, then again, why is he contacting witnesses in June and July? Because he's a fucking degenerate moron, rich billionaire, or apparently he's not a billionaire technically, but I think I know what they're talking about. And a person contacted my client on Signal, so it doesn't show up. I wanted to just talk to him, and he spoke to her. She contacted him, if that's the right thing I'm thinking about. He did not reach out to grand jury witnesses. I dispute that wholeheartedly. He didn't do it, and he wouldn't do it. Okay, let's get back to it. Again, the point that you're making, this all seems to be that this is just related. This is again to risk of flight. So tell me again why surrendering the passports and everything has something to do with danger. You're saying it shows respect for the court, respect for the proceedings. That seems like risk of flight. It's not on his rap sheet because he was acquitted, but it's well known that between 1999 and 2001, he had a very significant criminal case in Manhattan. He went to trial and he was acquitted. Over a 1-year period, he went to court every time because he was supposed to. During that over 1-year period, there were no issues with witnesses, there were no issues with danger, and he abided by the process. He showed respect for the court. He came to the court every day. He went to the trial, and a jury of 12 New Yorkers found him not guilty. So this is someone who actually has shown that when the chips are down and when the pressure is on, he doesn't do anything he's not supposed to do. He shows up on time. He shows up every day. He didn't do anything with witnesses, and that is a track record. That happened. That's not just his lawyer making an argument. He is not going to contact anybody. He's not going to reach out to anyone. He's going to let his lawyers do the defense investigation. But tell me more about this allegedly foolproof system that you're proposing. Under the system, would Mr. Combs still have employees? He will have employees. He has employees. People who manage his finances, they're not necessarily in the same house or located in California. Would it be necessary for him to speak with the employees, or someone on his behalf would speak with his employees? And under your proposal, would Mr. Combs be able to leave the residence? No, I don't anticipate that he will. Would your proposal be the security company you said they'd be there? Yes. There's his home in Florida. It's in Miami. He would live there and security personnel would live there. But the proposal is that they would just be in the house, not sitting there looking at him the whole time, correct? I don't know if they would need to sit there and look at him. I think we could just put cameras. We would put cameras at the entrance that are filming 24 hours a day, and they would be in the house and aware of the ongoings. Again, the video is quite disturbing, and it was 8 years ago, but he's still 46, 47 years old at the time of this taking place. And this was after his acquittal on the state court charges. The woman in the video also went to rehab around the same time. The point is, this was a 10-year relationship that was very loving at times. lives. These people loved each other, and I don't think there's any view of the relationship. Written messages, it's heartbreaking. It's sort of heartbreaking relationship in many ways because they really did love each other. I think the dynamic of the case that I object to most respectfully is this. The sex and the violence were totally separate and motivated by totally different things. The way this couple chose to be intimate was the way that it is. They would bring a third party into their intimacy. That was their thing. That is how these two adults chose to be intimate. What does that have to do with him punching her, throwing a vase at her, kicking her? What's love got to do with that? Good question, Judge. Absolutely nothing. He's a piece of shit. The problems are related to jealousy from infidelity. That is where the problems come. You have jealousy from infidelity. You have arguments. You have fights. Basically victim blaming for her freaking out on him cheating, basically. In both directions, both participants, and the violence is from that 100%. Let me just make sure I understand your point. What is your point on this? You're saying that that's the reason that because of jealousy, that's the reason they had an argument, that's the reason he punched her and threw a vase at her and kicked her. I'm saying it's not sex trafficking. The government is linking the two, and in the linkage, they found sex trafficking. The government is also talking more generally about the violence against women, and violence against this particular woman who the government claims was sex trafficked. And let me ask you this thing. If you're talking about the extent that you claim that this sort of behavior was, that inviting another person in the relationship was somehow consensual, person is a sex worker, prostitute, and travels across state lines, isn't that a problem regarding the count 3 of the indictment? Defense responds, it may or may not be. I've spoken to people from this agency and they say we are not paid to have sex. We are paid for our time. And if we meet somebody and it goes in that direction, everybody wants to do this, there's sexual contact, and that happens sometimes. This is so bad, dude. We're not paid for sex. We're paid for our time. Governor of New York was investigated by Southern District of New York because he was sleeping with 5,000 an hour prostitutes while he was governor. They didn't prosecute him. They were prosecuting Ms. Combs for the exact same type of conduct. But then Diddy drug them, beat them, coerce them, threaten them, damage them beyond repair, and pretty much almost ruin lives. Let's get back to the video. Why isn't that relevant to the consideration as to danger to the community? I think it's relevant. I think it is relevant. I haven't said it wasn't relevant. I'm saying it's not part of the sex trafficking. That's my theory. Is it relevant? Your Honor is going to look at the video the way everybody looked at the video. Mr. Combs issued an apology after the video, and I'm not going to undo his apology. It's a hard video to watch. It's upsetting. It's 8.5 years ago. He went into rehab since then. He's done tremendous things to try and change as a person since then. He's not the same person as he was then. He was in a relationship that was toxic. They broke up 6 years ago. If the court doesn't fully trust him, trust the package as a whole. $50 million, surrender passport, family's passport, electronic monitoring, stays in the house, intelligence supervises the house, list of permitted visitors, no cell phone, doesn't have internet access. He's not a danger, not a flight risk. First of all, he has one misdemeanor conviction from 29 years ago. That's it. He's 53 years old. One misdemeanor conviction. He was an actual altar boy growing up. He's a very religious man. Come the fuck. What? Just what a disastrous defense here for someone trying to get on bail. He's religious. Growing up, he was religious. You gotta let him out. Yes, he's on video beating the shit out of that girl, but he's religious. How far are you going back now? I'm talking about him as a person because it's all in one continuum. He watches a sermon every day. He's religious. He comes from a religious family. His father, unfortunately, was killed when he was 2. He was raised by his mother, who did a wonderful job with him. Yeah, his mom totally did a good job. Blah, 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 the package, blah, 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 flying to Florida, blah, blah, blah. I'm gonna ask you to release him on these very strenuous conditions. I've heard from the parties that reviewed everything. I find the government has proven that the defendant is a danger regarding obstruction of justice and witness tampering by clear and convincing evidence. I find that the government has proven that the defendant is a danger to the safety of others in the community. I need not reach the issue of risk of flight. Again, I find the government has carried its burden of persuasion. I think it's insufficient, the bail package. So I'm denying bail and I'm granting the government's motion. And that's pretty much it for the transcript from that bail hearing. We already knew the bail was denied, but the back and forth between the defense and the judge is not looking good. It looks like his defense lawyers they didn't really have much defense to the video because it's on video. He's beating the shit out of his girlfriend on video. He's screwed. Yeah, that's pretty much it. Hit subscribe, join the channel membership. Love you guys. Peace out.